Welcome to law school and welcome to this course on contract law. I'm Chris Gulanello and I will be your instructor for this course. In this first unit, we're going to lay the groundwork and the foundations for your study of contract law. In this subunit, we're going to talk about the structure of the course and we'll introduce the basic policies underlying contract law. I hope you enjoy this course very much. All right, once again, welcome to law school. Now let's get to work. Law school is pretty demanding, but it's nothing beyond your capabilities. Remember what we are here, we're a professional program. We are trying to train you to become lawyers. We are trying to train you to become professionals. And as such, our goals and our methods are a little bit different than what you might have experienced in your undergraduate educations. Remember when you were an undergraduate and you can kind of coast through a course, and at the end of the course you can kind of cram for 4 or 5 hours and you would do really well on an exam? That is not going to happen in law school. You have to put in the work from day one till the final exam. And studying a few hours for the final exam is not going to get you the grade that you want. As you're going through this course, if you're thinking, I have a really good idea of contract law, that's probably not good enough. Your goal has to be an expert on contract law by the end of the course. Right? And I'm here to help you, and the exercises and the lectures and the things we do in class are all there to help you reach your goal of being an expert on contract law by the end of the course. But I really can't teach you anything. I can just kind of be a guide. You have to teach all of this to yourself. Right? One of the most precious gifts that you can give to yourself in law school is learning how to teach things to yourself. Once again, I'm not just going to throw you into the deep end. We have these lectures, there's things we're doing in class. So we're going to give you the environment so that you can become an expert on contract law. But without you putting in the work and without you putting in the hours, you're not going to be successful, right? I know you want to be successful, so make sure you do all this work and think of the end goal that you need to be an expert in contract law by the end of this course. Let's talk about these online lectures, how you should approach them, and what I expect you to take from them. First, these online lectures are not optional, they're mandatory. Please treat them like any other class. Pay attention, take notes, don't skip parts, but you have the added benefit of being able to watch these lectures whenever you want. So if you don't understand something, you can rewatch the appropriate lecture, or if you want to review something, you can rewatch the appropriate lecture. Please, before you come to class, make sure you know the content of the lectures. Now remember, your goal is not to have a good basic idea of the content of the lectures before coming to class. Hopefully, you can make yourself an expert to the best of your ability on the content of the lectures before coming to class. What are we going to do in class? Well, the first thing we're going to do is I'm going to make sure you understand the content of the lectures. So I'm going to ask you things based on what is discussed in the lectures. Then I'm going to introduce some new and maybe novel fact patterns, and hopefully based on what you've learned in the lectures, we'll be able to have a good discussion and solve these issues without much difficulty. Thirdly, we're then going to expand your knowledge, right? So the lectures are kind of the foundational knowledge that you need to know. Once you have that foundation, then it is possible to build on that knowledge. All right, here's the basic roadmap for the course. The course is divided into 2 large parts. We'll call the first part Contracts 1 and the second part Contracts 2. Contracts 1 deals with the formation of contracts. I'm not going to read through all of the topics that we're going to discuss. If you really want to read through them, you can pause it here. But in short, there are several issues that we need to discuss to determine whether the parties have actually formed a contract. The second part of our course, Contracts 2, is the performance and breach of contracts. Once again, I'm not going to read out all of the subtopics. If you want to, you can pause it here and read through them. You're going to become intimately familiar with all of these subtopics as we go through the course. Let's discuss some of the policies underlying contract law. Why do we have contract law, and what is the function of contract law? Before we do that, let's just look at a simple transaction, an exchange between parties. So, Sally has a laptop, but she would rather have cash than the laptop. Betty has cash, but she would rather have a laptop than the cash. So, Sally sells the laptop to Betty for $100. This is a win-win situation. Each party is better off. An economist would say each party has increased her utility. How do we know that the parties have increased their utility? How can we measure it? Well, we don't try to. What we do is we let the parties decide. And because the parties entered into this exchange where Sally gave up her laptop for cash and Betty gave up her cash for a laptop, we assume that the parties are each better off. Why? Because they entered into the transaction. If they wouldn't be better off, they wouldn't have entered into their transaction. All right, so we just looked at an exchange and we said the exchange was good for both parties. Each party increased her utility. Now the question is, what is the function of contract law in these exchanges? And simply put, the function of contract law is to make promises between the parties legally binding. All right, so let's change the fact pattern just a little bit. In our fact pattern, Sally promises to sell the laptop to Betty for $100, and Betty promises to buy the laptop from Sally for $100. This is the paradigm of the contract. Promises that are legally binding. What is the good of having promises that are legally binding? Well, legally binding promises increases the certainty of the promises. We just said that legally binding promises give certainty to these promises. So why is certainty so important? And the answer is it reduces transaction costs, right? Without legally binding promises, exchanges and transactions would be more costly for the parties. Okay? Let's imagine a world where promises are not legally binding. Now, the first question I'm going to ask is, does that mean that you cannot enter into exchanges or transactions? And the answer is no. But what kind of exchanges and transactions can you enter into? Well, you could enter into contemporaneous exchanges, exchanges that don't require future performance, right? Here I'm paying you and you're handing over the goods. It's a contemporaneous exchange. There's no promises to do anything in the future, right? You see how this limits my options. And anytime you limit my options to enter into an exchange or transaction, you're increasing my costs. Now, I might be able to enter into future exchanges, but I'll only enter into future exchanges or exchanges that involve future performance when I trust the other party. Right? Establishing a relationship of trust is a costly process. Thirdly, I can enter into exchanges that involve some sort of future performance, but to guarantee that the other party will perform, I will need some sort of collateral, right? The other party is going to have to give me something. So if they do not perform, I have the collateral. So we're discussing why promises, why contracts should be legally binding. And it kind of comes down to two basic ideas. The first idea is that I want to be legally bound by my promises. If I am not legally bound to my promise, then my promise has less value. And so when I try and exchange something for my promise has very little value. So for example, what if I say to you, please give me the goods today and I will pay you in a week? If my promise is not legally binding, it has very little value. And if it has very little value, why would you exchange the goods today for my promise to do something in the future? And so if I want to be able to get the goods I need now in exchange for a promise, my promise has to be legally binding. So I want my promise to be legally binding. Secondly, I want your promise to be legally binding. When you promise something to me, when you promise to deliver something to me in the future, or perform services for me in the future, or to pay me in the future for something now, or even if I don't give you something now, I want your promise to be binding. Why? Because now I can engage in planning based on your promise. Well, what does that mean exactly? Well, I can plan for other transactions. This transaction, this thing I need in the future, I have settled that with you and I'm going to get that in the future. So now I don't have to go look around and find some way to solve that problem. I've already solved that problem with this contract with you. And I can now go out and solve another problem. That's just one example of the socially beneficial planning I can engage in because our contract is legally binding. So because we have these two ideas, number one, I want to be legally bound, and number two, I want you to be legally bound, we have strong support for a system of contract law that binds us legally to our promises. So what role does contract law play in all of this? Well, first, we know that contract law will generally make your promises legally binding. Right? Now, the theme throughout the course, right, no matter what we're studying, is usually there's going to be somebody that says, I should not be legally bound. Right? They're trying to get out of their promise. Either they're arguing there was no contract and I should not be legally bound, and this is what we're going to discuss in Contracts 1, the formation of contract. When have parties formed a legally binding contract? Or they might say there is a contract, but I should be relieved of my obligations under the contract for some other reason. And we'll discuss the various scenarios that implicate this type of argument. Right? But in the end, it comes down to this. Before the contract, the party wants to be legally bound. Why do you want to be legally bound? Well, we discussed this. The only way you can get something from somebody else is if you are legally bound to your promise. But then afterwards, something happens where the party regrets her decision. She says, ooh, I wanted to be legally bound, but now this transaction isn't that good for me and I want to get out of it, right? And so the law has to strike a balance. Remember, one of the ideas of these exchanges is that you increase your utility. If you discover that this transaction does not increase your utility and you want out of it, should we let you out of it? The initial answer might be, yes, we should let you out of it because the whole idea of the exchange is for both parties to increase their utility. It's a win-win situation, and so therefore we should let you out of a transaction if it doesn't increase your utility. But we have to balance this against the other policies that underlie contract law, right? So if we let you out of your promise, it undermines your ability to bind yourself. And remember, you want to be legally bound. If you can't legally bind yourself, how are you going to get something from somebody else? So if we let you out of this promise, then we are watering down contract law. We are undermining your ability to bind yourself. Your promise has less value in the future. Yes, you want to get out of this contract, but let's look at the effect that letting you out of this contract will have on you and on everybody else. And we don't want to undermine contract law. We don't want to undermine your ability to legally bind yourself to the promise, right? This hurts you, and it also hurts the other party. If we're going to let people out of contracts, right, much more easily, then the other parties are not going to be able to engage in that socially beneficial planning that they would have engaged in otherwise. So this is the balance that contract law needs to strike. And as we go through the semester, we'll ask ourselves, is the law here striking the right balance?